Chair Lynch-Prada and members of the Judiciary Committee, good evening. My name is Lynette Labinger, and I'm a cooperating attorney with the ACLU of Rhode Island. We have reached a critical juncture in our cultural and legal landscape. The status quo in which the right of reproductive choice is preserved by federal decisions starting with Roe v. Wade is about to unravel. To borrow from another cultural and legal phenomenon, time's up. And just to address the comments that were just made by, we say in the legal business, my brother and Mr. Kavanaugh, who I respect greatly, but disagree with even more on this decision. I've been before you, I've been before other committees, I've been working in this area a long time. I'm not aware of anyone who actually is an advocate of reproductive choice, who is taking the position of the right to life movement that there's no, that Roe is guaranteed and there's no need, that we can be complacent now. That's not coming from people who believe in reproductive choice. And I would suggest to you that if and when Roe does unravel, those same voices who are telling you now that there's nothing to do and there's no need to do anything because Roe is the law of the land will immediately be arguing to you that all of these laws that are still on the books that have been previously been declared unconstitutional should rise up on their own and restrict women's and pregnant individuals' right to make their own personal decision with consultation with their physician about whether to keep or terminate a pregnancy. If reproductive choice, as we presently know it, is to be preserved in Rhode Island, the General Assembly needs to act now and pass Senate Bill 152 sub A, the Reproductive Privacy Act, which does simply that: codify the principles of Roe v. Wade and later decisions, and repeal unconstitutional provisions remaining on the Rhode Island statute books which conflict with those principles, and nothing more or less. I would like to walk you through the provisions of Substitute A to show you how it does that, and nothing more or less. Section 1 is the proactive section which recites the principles of reproductive choice that are established by Roe v. Wade and later cases, for which I will use the shorthand Roe principles. It is written in descriptive terms which set forth the Roe principles to prevent any claim of ambiguity or confusion about what is meant. And what is meant, as in the Roe principles, is that the decision whether or not to continue a pregnancy to term is declared by our state to rest with the individual pregnant person and her physician. It says that the state can never interfere with the individual's decision to carry a pregnancy to term if she so chooses. That's to keep the pregnancy. And that the state can interfere with the individual's decision to end the pregnancy after viability, except when that decision is necessary to preserve her life or health. Section 1 includes the definition of fetal viability described in Roe, and which the U.S. Supreme Court made clear is a medical determination in Planned Parenthood versus Danforth in 1976. Section 1 also makes clear that codifying the Roe principles into Rhode Island law will not alter the current state laws that are in force which create limitations on abortion, and which do so constitutionally and consistently with Roe principles. Thus, Section 1 recites, not only by their statutory reference, but also by their title, the numerous state laws currently regulating abortion that conform to Roe principles and therefore are not abrogated or negated by the bill. These provisions required informed consent before the abortion is performed, preserve the right of medical participants to decline to participate in abortion or sterilization based on religious or moral objections, require medical care to an infant born alive during an abortion, severely restrict fetal experimentation, and exclude abortions from state-funded family planning services. All of these laws remain in operation just as they are operating now. In addition, Sub A makes explicit what was implicit in the original version of S-152, that the federal ban on partial birth abortion is not in any way restricted or otherwise affected by the bill. The Sub A further contains express language confirming that all authorized methods of contraception and abortion must also conform with all relevant state and federal laws and Department of Health regulations that comport with the Roe principles. I am aware of criticism that the original version of the bill did not explicitly prohibit post-viability abortions that were not necessary to preserve the individual's life or health. The sub-A states expressly what was implicit in the original bill. It adds a
Lynette, just so you know, you're at about 5 minutes, so I'm going to let you go a few more minutes, but I just want you to know when I cut you off, that's why.
Thank you. A new subsection D makes clear that termination of pregnancy after fetal viability is expressly prohibited, except when necessary to preserve the pregnant person's life or health, and provides for a enforcement through the professional misconduct proceedings before the director of the Department of Health. There is also a new Section 9, which likewise makes explicit the requirement that a minor cannot obtain an abortion without parental or judicial consent, which is expressly preserved as a prohibition, with the addition of limited permission for a grandparent or adult sibling to provide consent, but only in the case of death or unavailability of the minor's parents.
Lynette, is that something that your organization has taken a position on one way or another?
No.
And the reason why I ask that is, again, as most everyone in here knows, I spend my life in the family court, and I have some real concerns about giving parental rights to people that are not expressly, shouldn't have them otherwise. So I think the language that's currently there covers what needs to be covered, and there is judicial bypass, as you stated, and none of that's changed, right?
That's correct. And we do not take a position on it. We believe that, though we don't take a position on it, that it's consistent with Roe principles, but it's not required by Roe principles to have those additional categories.
Senator Lombardi.
Lynette, since we're in the habit of interrupting now, I might as well.
Can you put a pause on my timer?
Absolutely.
Thank you.
Absolutely. Although I do owe you about 6 hours of deposition testimony from years
No, I think
back.
I owe you back.
But that's another story. My question to you is, and I've been writing notes as we go along here, is have we ever codified by state law anything that's already been defined as a constitutional right? So in other words, I'm asking, why the need to do this today? Almost like Joe Kavanaugh's question, and forgive me for being long-winded.
I'm sorry, I don't mean to interrupt.
No, go ahead.
We have a provision in our state constitution which is hostile to reproductive choice. In the, I think it's Article 1, Section 2, which provides for due process and equal protection. It says, however, this shall not be construed to provide any right to abortion or for public funding of abortion. That's on our books. It is hostile. In the event that there's a change, as we expect there will be shortly, at the federal level, what we have is a hostility toward reproductive choice in Rhode Island.
But, excuse me, I don't mean to interrupt, but how would this statute, if passed, usurp a constitutional mandate?
It's not a mandate, it's a limitation. It says that there's nothing in the Constitution that provide. In other words, in some other states where these issues have come up, they have challenged laws interfering with reproductive choice. And their state Supreme Court looks at their Constitution, their privacy interests, their due process, their equal protection clause, and similar to what the Supreme Court did in the Roe case and cases following it, finds that as a matter of state constitutional law, there is a basis to provide for, prevent interference by statute with the woman's or the pregnant person's right to make this decision in consultation with their physician. We don't have that here because we don't have that in our Constitution. That's why this law is so necessary, because it expresses the intent of the legislature to preserve those rights as a matter of Rhode Island law, so Rhode Island women and pregnant individuals are no longer having to look only and exclusively to what federal precedent exists to protect them from interference with their own very personal decisions as to whether or not to carry a pregnancy to term.
Sorry,
Senator Lombardi.
One more question, so that we can, and I'll shut up after this. The issue of health and the definition of health, as has been pointed out by the other side. where do you look in this statute to give the definition of what constitutes health?
I fall back to the Roe cases, which do not have a clear, they don't spell out this is health and that isn't, because it's a slippery slope. All of a sudden somebody says, well, they have to be committed, as one of your witnesses said, they have to have a total mental breakdown. There's an earlier U.S. Supreme Court case called U.S. versus Vooch that there was an argument that the term health in a statute, and that was a criminal statute, was too vague to prosecute someone, and the Supreme Court said, no, that's commonly understood. And remember, our whole point is that these are medical and personal decisions, and respectfully, I don't want the legislature trying to tell my doctor or someone in my family's doctor in consultation with that individual how to make a determination as to what their state of health is. It's sufficiently clear, and the decisions are very serious, that it is, I think, somewhat disrespectful of the individual who's facing this enormous decision to suggest that it is like deciding, as I've been accused of, what pair of shoes to wear today. These are really important decisions, and they are taken that way by people who are faced with them. So that is why we conform to the federal standards that use these terms and have been used successfully in the state since the Roe cases were put into place. Have I responded?
Yes, you have. Thank
Okay.
you.
All right, I'm going to have to speed read again.
You can certainly, if you have prepared testimony, you can also certainly provide it to us.
I will do that.
Okay.
So there's no ambiguity or confusion in passing a law preserving reproductive choice. The rest of sub A is devoted to clearing up state law to get rid of unconstitutional provisions that have either been struck down or never enforced. And that is in sections 2 through 6, which repeal laws still on the books that have previously been declared or acknowledged as unconstitutional and never enforced. I will skip what each one of them is, but each one of them has been addressed by a case, and they are not in effect. So they are not part of the fabric of the Roe principles in place in Rhode Island, so leaving them on the books would not conform to an action which is designed to preserve and codify Roe. I just mentioned Section 7 revises state law preserving the prohibition on state funding of abortion and health insurance, but removes 5 words which relate to municipal employees and which was declared unconstitutional in 1984. I'm aware of recent press coverage claiming that this language represents a change towards allowing taxpayer funding of abortions, but that is absolutely incorrect. The removal of the 5 words would just conform to the judicial invalidation of the state's effort to interfere with municipal choices on whether to provide abortion coverage in their employees' comprehensive health insurance that has never been in effect, and each municipality retains the right to decide on its own. There is no mandate of state funding or abortion beyond the current standards. For those of us who believe that the status quo does not go far enough in preserving and protecting reproductive choice, S152 sub A does not go far enough. For those who believe that the status quo goes too far because it does not protect fetal life, S152 does nothing to roll that back. In short, it does nothing new in terms of the current state of reproductive choice. What it does do, if enacted, is preserve the current state of reproductive choice as a matter of Rhode Island law so as to no longer be dependent upon principles of federal court decisions to provide such protections. Without its passage, reproductive choice in Rhode Island rests on the next decision of the U.S. Supreme Court. Truly, time's up. I will provide my remarks, and I'm pleased to answer any additional questions that you may have.
Thank you. Senator Aptakis.
Quick question for you. You kept mentioning the word about to unravel Roe versus Wade, yet I haven't seen, or if you've seen, any legislation in the General Assembly that's going to cause that. if there's any legislation in Congress that's going to cause that, or if there's an argument in the Supreme Court that's been introduced to cause that. I'm not finished. And that's my concern, because there is a lot of that going out. I'm looking for facts and the truth. And we keep going into the other portion of your testimony where you said there's statute or law that's been passed in Rhode Island that's hostile to Roe versus Wade. And I'm just curious, because I know there's arguments out there, but we want the facts also. And everybody keeps using the word about to unravel, but none of those 3 points that I just brought up are taking, none of those have started or in the process of occurring.
Well, I believe there's about 16 cases that are wending their way to the U.S. Supreme Court right now, and there's a lot of hostility in other jurisdictions than Rhode Island, where they are clearly trying to find the case to bring back to the U.S. Supreme Court to unravel Roe principles. That can happen in an instant, and for individuals who find themselves pregnant and in need of a decision, they can't wait until this General Assembly decides it's time to take it up. You do things in anticipation of issues, many times appropriately so, to recognize, I mean, you pass budgets, you know that you're going to need to spend money, you do planning. This is planning at the very basic, important decisions for a whole host of Rhode Island individuals who are facing these issues and can find their ability to make this important personal, very personal decision gone in a moment.